SJC-13015 in the matter of an impounded case.
Okay, Mr. Tennant.
Good morning, Your Honors. Eric Tennant on behalf of the plaintiff appellant. Thank you for having us in the courtroom again. It's nice to be here. A DCF social worker wears many hats, but perhaps none more important than when they seek a court order to seize a child. And in that instant, they function outside of the judicial phase as a complaining witness. And a complaining witness is a role that has never enjoyed absolute immunity. This court should not change that. The rule we seek is narrow. It's not going to open Pandora's box. There's not a problem with social workers constantly lying to get court orders. But when they do, and it can be proven, they should be held liable for that. I think the problem, the disagreements here and what the court is going to have to grapple with is how to define the social worker's function in this case, in cases like this, when they act in this way. Because like I said, they do wear different hats. Some of the things they do might fall under the rubric of absolute immunity, but not everything. Some of the things they do should fall under the rubric of qualified immunity. So the court is going to have to draw by analogy, and because it's just not a perfect fit, right? We don't have prosecutors and police officers where the case law is a little clearer and helps us figure it out. So let's talk a little bit about analogies and how we should think about this.
Before we move to analogies, can we talk about the statute itself? Because the statute prescribes in specific detail what needs to be in the initiating document, right? And it's not just the petition, but it's a specific facts needs to be alleged. So I don't understand how we cannot find this as initiating the prosecution here. So why don't you address that?
Sure, I don't disagree that the statute sets out a process. I just don't think that matters. I think that's tangential to what the function is when you're talking about immunity. You still have to decide what function the person is playing, even if they're following a statutory scheme that tells them what they have to do.
Well, but the function is prescribed by the statute, which is defining the documents that need to be basically the equivalent of an indictment. It's defining what needs to be in that piece, those pieces of paper to start the process. So it just seems to me that we have to look at the statute to define the function.
I see it differently, Your Honor, and this is part of the problem. And if you don't like my analogy, then there's not much I can do about it. But my analogy is
all you need to do is convince more people that you're right. So don't worry about me, but you do need to address the merits.
Fair enough. My analogy, it is more akin to a police officer seeking a warrant to seize, where they have to, where there are statutes that say what you have to do to fulfill a warrant. We have case law that tells us what kinds of things have to be in there. It has to be particular, what burdens we're talking about. You have to have probable cause. Sometimes in that process, a police officer will go and have an ex parte communication with the judge, just like they do in a DCF proceeding, right? Where they say, can you explain to me what you meant by this or that? And they have that communication. And then they have.
But don't we have a difference here? Because basically, using this analogy, the statute defines what needs to be in the indictment, essentially. And here the statute defines what needs to be in this petition, correct?
Yes, I don't disagree with that.
So why isn't it it's part of the prosecution as opposed to part of the investigation? I understand you could draw a firm line of everything these DCF workers did before they file that piece of paper and say that's only covered by quasi-immunity. But if the document that initiates the petition has to include this, aren't they moving to the prosecutorial function at that point?
So let me give you a slightly different analogy. And this comes right from the case law. So when you look at what is undisputed in terms of qualified immunity and social workers, at least through the federal cases, we know that social workers enjoy only qualified immunities when they take custody of a child without a court order. So it is something that can be done on an emergency basis. Massachusetts allows for that. Other states allow for that. A social worker can do that. There's an emergency. I'm making a judgment that I need to take this child right now. I then have an obligation to get a court order as soon as I can after that. And that happens sometimes, maybe more than we think. So when a social worker does that, the cases are uniform. It's only qualified immunity. And there is a standard that they have to reach. There's a constitutional threshold for taking a child without a court order. So that process, that function of making a determination that this is a child that has to be taken from the house enjoys only qualified immunity when it's without court order, whatever, sort of warrantless, if you will. Why should it be different when they seek the court order? The functioning in the same way, just the way they're going about it is slightly different. Instead of taking the child on their own in the moment, they're going to the court first, but they're making the same sort of decisions. They have the same sort of burdens, which is they have to at least show that there's an emergency, that there's reasonable suspicion, things like that.
Well, the reason might be, you asked why would you? And when you're dealing with the functional approach, what you have is a concern and a very difficult decision. The stakes are enormous. The procedure, as Justice Kafka said, requires the affidavit, that it's going to chill these social workers in just a situation where there's enough trepidation as it is.
I can't imagine a rule that says don't lie is going to chill social work.
Yes, and that is true.
Okay.
But there's perjury. It's don't lie is a big statement. That's a huge statement. And that is absolutely right. We got kids and parents at stake, and we also have perjury.
But it's the same. I mean, if we want to talk about it in the sort of that policy way, it's the same rule we hold police officers to, and no one, thinks secondly about that, which is when you seek a warrant, you must be truthful, and if you're not, you could be liable.
But
That's the only. It's
and we
an
know from the
analogous
United States Supreme Court and Catalina, we understand that there's a line there, and I understand why you're arguing. You're on this side of the line with your analogy to search warrants with police officers, but there's a lot of United States Court of Appeals cases going the other way because of the public policy concern on the other side. And this is nothing other than a very difficult choice.
Oh, I know that. I think, so let's clear up a couple things, because there's a lot of cases that talk about the seizure without a court order, and those are in only one direction, qualified immunity. Then when you have the cases where they first take out, or when they first seek the court order, like this case, I think there's not a lot of cases, and to the extent they have cases, they're fairly split, I think. And if you want to talk policy, to the extent that plays a role in this, and I think it plays a small role, not a large role, because function is function, it is what it is. But the policy, when you think about immunity, is absolute immunity is disfavored, right? We do not want to just give absolute immunity. We have to, it has to really be something that was enshrined in the common law before we do that, because we do not like the idea of not holding people liable when they should be liable. So to the extent policy plays a role, it seems clear that the policy is on my side. There's a wonderful amicus brief by CPCS that talks about the trauma that comes with being taken from the home. When a child is taken from the home, the lasting effects of that, how these seizures from the home fall disproportionately on minorities and the poor. And so all we are saying is, we understand that has to happen sometimes, but if you're going to do that, you as a social worker, you at least have to represent the truth of what is going on. And if you're going to do it on your own, without a court order, which you have the power to do, make sure you meet that threshold of reasonable suspicion of imminent harm, or as the test says, or if you're going to go to a judge, make sure you represent honestly what's going on, so then the decision's on the judge and not on you. And if you think it should happen and the judge says no, that's not your fault.
But the decision is on the judge anyway. And so the judge is going to decide whether to separate the child from the parent, right? Not DCF. Although in your first analogy, when they take them without a process, then they really are on their own. And if they're doing it wrong, they're not going to have absolute immunity. The only issue we're dealing with is this statutorily required affidavit to be attached to the initial document that sets this process in motion. That's all we're talking about, right? And also they can be convicted of perjury if they lie in court, correct?
I assume they can.
Yeah, they can be.
Although I will say I'm not 100% sure, so don't hold me to this, if they are under oath when they have an ex parte proceeding with the judge or not. I don't know enough about that process to know, how that works, if it's just a proceeding where they're explaining it or not. I know when the police go in for warrants, they're not under oath.
And the policy is complicated because, we have lots of these cases where children are being abused. And if the DCF worker is frightened about beginning the process, they're not going to do anything. And it's not just lying. That's easy. The question is, who's lying? Are they lying or are the parents lying? And we don't know that until we try the case, right?
I disagree with that.
Short circuit everything under you. This has the potential to short circuit the process, right? If you're afraid of being sued and all that entails, we don't start the process.
I do not think that there is a backlog of cases ready to be filed because people are going to start alleging that social workers are lying across the board to get complaints. A social worker needs to represent objectively what that social worker knows. If that social worker has been lied to by a parent or something else, that doesn't mean that she has misrepresented something in an affidavit in an attempt to get a court order. They're not liable for that. It's only when they do not represent what they objectively know so that they can get an order.
But these things are passionate fights by both sides. And sorting out the truth is not the simplest thing on earth. It's very difficult. That's why we have a trial. So these things are filled with accusations and counter accusations. And the question sort of, again, is that affidavit part of the prosecutorial function or not?
I do think that looking only at the affidavit and saying this is how we're going to figure it out is a little too formalistic. That it doesn't matter for functionality how you get there or what you're doing. It's literally just what is the function of what you're doing, whether the statute tells you to do it this way or that way, whether it says to do it under oath or not, or that you have to include the parents' addresses or not, or whatever it is.
How can that possibly be true? If the statute defines the prosecution process, how can it be irrelevant to the function? I just don't understand that.
Because the statute doesn't say this is the prosecution process. That's how you are describing it as a prosecution process.
What does the statute say? What does the statute say has to be in that petition?
I don't know the details of what exactly has to be in that petition, but I imagine it says you have to set out the criteria that you need to show that there is an imminent emergency to, for the court to issue an order giving DCF temporary custody. But it doesn't describe it as a prosecutorial function. Nothing describes these proceedings as prosecutorial because they're not. This is not the Commonwealth prosecuting someone for a criminal act. This is the Commonwealth saying, we think there's a problem in the home and we're going to step in to try and rectify this temporarily or permanently. It's not a prosecution. That's what makes this difficult. The analogies are, we have to decide whether it's like a prosecution. Not that it is, it's like a prosecution because the case law tells us to do one thing.
Does that mean the DCF lawyers are also not protected then? Are you saying that DCF lawyers are also only protected by qualified immunity as opposed to absolute immunity? Because this isn't a prosecution, it's a civil proceeding?
DCF lawyers do not get involved until after there's a petition, then they come in and represent the department. At that point, you're at the judicial phase. I would not call it a prosecution, but by analogy, I'm willing to say the analogy there is they are in the judicial phase in which lawyers enjoy absolute immunity.
So your view is then that this whole thing, you're either within the judicial immunity, there is no prosecutorial absolute immunity in play whatsoever in this process.
No, not that it's judicial immunity, that prosecutors enjoy immunity for being in the judicial phase. Prosecutors, there are things when they're not in the judicial phase that they do not enjoy absolute immunity for. So you can't just say it's a prosecutorial immunity. It's still absolute or qualified depending on where you are in the process.
But it's absolute or qualified. The question is what we call the prosecutor's common law privilege and in play here at all? It seems like you're arguing that it only applies in the criminal process. When a prosecutor in a criminal process, he has a prosecutorial immunity, not just a judicial immunity.
So I'm not arguing that, Your Honor. What I'm saying is, in terms of trying to find the analogies here, once you are in the judicial phase, we can call it, you can call it prosecutorial immunity, that's fine. The prosecutor enjoys absolute immunity for any actions they take once they are in the judicial phase. A prosecutor does not enjoy absolute immunity for functions and actions they take prior to a judicial phase. The case law talks about times where a prosecutor can be liable. So simply calling it prosecutorial immunity doesn't answer the question. It's how are you functioning? Are you functioning as an actor that is entitled to absolute immunity?
Which is are you functioning as a prosecutor or are you functioning as an investigator?
Sure, that's one way of thinking about it. So what I'm saying in these cases is that when the social worker goes to get a court order, by analogy, I do not consider that being part of the judicial phase. So they don't enjoy the immunities that are enjoyed when someone is in the judicial phase.
You're skipping a phase. There are three phases. There's the investigatory phase, there's the prosecutorial phase, and there's the judicial phase. We're dealing with not whether this affidavit fits within the judicial phase, it's whether it fits within the prosecutorial phase of immunity, or is it investigatory, right? That's the question we have to answer.
So if you want to put it that way, I would say it doesn't. And again, because we know that if a social worker does this same thing without a court order, they have qualified immunity. I don't see what difference her function is when then she's seeking a court order to do the very same thing she only has qualified immunity for. They only have qualified immunity for.
Okay. Does anyone have any other questions?
Thanks, Chief.
Thank you so much.
Thank you, Your Honors.
Mr. Bruton.
Thank you, Chief Justice Budd, and may it please the court. When social worker Marcy Plouffe executed and submitted the affidavit in this case, she performed a function that only she could perform, and that as a matter of Massachusetts law, she personally had to perform in order to initiate the case on behalf of the department. So if we accept, as the appeals court did here, and as courts across the country have held as well, that a social worker is absolutely immune for initiating the case, it should then follow that the same social worker in Massachusetts—
It's not initiating it, it's prosecuting it, right? There's a difference, right? Is my formulation incorrect that there are three different phases? There's the investigatory, there's the prosecutorial, and the judicial. And obviously the prosecutorial and the judicial merge very quickly. But
I think I agree with that formulation, Justice Kafker. There is the investigatory phase, there is the prosecutorial phase, and there's the adjudicatory or judicial phase. Cases like Imbler from the Supreme Court and Butts from the Supreme Court tell us that the initiation of the prosecution is part of the prosecutorial phase. So
not all of it. Some of it's got to fit within an investigatory function, like the function performed by the police on the criminal side, right? I mean, well, not everything. It can't be that all of her investigation is protected by the prosecutorial function, because then we've eliminated the first phase of this.
No, it can't be, Justice Kafker, but the act of going to court to initiate the case on behalf of the department is protected by absolute immunity, just as a criminal prosecutor seeking an indictment or me as a civil AAG filing a complaint on behalf of the Attorney General's office would be. Now, here—
And your brother argues the first stage where they appear ex parte, this is before the affidavit stage we're dealing with now. Do you think that's covered by the prosecutorial function, where they come in and seek this kind of immediate ex parte relief? She's acting as a prosecutor there, or is she acting as an investigator there?
So Justice Kaffer, I want to be, I want to answer that question. I also want to be precise about what happened in this case. Obviously, the department under Section 51B can take emergency removal before filing the care and protection petition. That's not what happened here. What happened here was Marcy Plouffe went to court, had the ex parte hearing, and then based on the Dudley Juvenile Court's order, took emergency custody. So in this case, the case initiation preceded taking custody of the child. Now, in the hypothetical my brother is discussing where a social worker takes custody before ever going to court, I certainly agree that that would be a much harder case for us as an absolute immunity matter because we would not have the prosecutorial conduct. Here, Marcy Plouffe was acting as a prosecutor because in order to initiate the case, she necessarily had to sign the affidavit. Now, in the Kalina case,
Counsel, could you just answer one question for me? After the 51B process and the emergency removal of the child, what happens?
So let's take this case for an example. Marcy Plouffe filed the petition and affidavit, went into the Dudley Juvenile Court the same day for the initial ex parte hearing with the judge. The judge granted custody to DCF. Now, the next thing that happens under Section 24 is that the social worker is responsible for notice and service.
No, I mean, what happens in the circumstance where there isn't an initial petition to the court? It's the emergency removal without seeking court approval.
In the other circumstance that isn't this case. Okay,
Right.
so-
What happens?
Right. So under Section 24 and Section 51B, DCF has to file a petition on the next court day.
Okay, that's what I'm getting at.
Yeah.
So I'm interested in your response to Attorney Tennant's point of you don't argue that under the emergency immediate removal that there's absolute immunity. Right.
We're not making that argument in this case. I'm not prepared. I haven't thought a lot about that, Justice
Well,
Georges.
that's important
Yeah.
because the analogy he's giving us is the functions are the same. The social worker is performing the same function when they're doing it without getting judicial imprimatur as when they filed the affidavit and begin a more formalized process. They're doing the exact same thing. So why in one you get absolute and the other you get qualified?
Because the function being challenged here, the basis for liability purportedly in this case, is that the case initiating documents in the juvenile court contain misrepresentations. So the plaintiff in this case is challenging the removal only indirectly. What the basis of her claim is that the case initiating documents contain misrepresentations. And that is what brings us into the prosecutorial immunity cases. Kalina is important, and I want to talk about Kalina. In that case, the prosecutor was not acting as an advocate when she signed the affidavit. So the Supreme Court tells us that the prosecutor was immune for filing the motion, for preparing the affidavit, but not for personally signing an affidavit in support of an arrest warrant under oath.
But Kalina is tricky, and it cuts somewhat against you too, because there the Supreme Court criticizes the prosecutor for taking over the function of the police officer, which was to prepare the factual basis for this and attesting to facts that the police officer should have. Here, that function is sort of being merged into one because the DCF person is both the prosecutor and the investigator, right? That's what makes this harder than Kalina, because it's.
I think that's absolutely a fair characterization of the role, broadly speaking. In the social work context, the person who is the investigator also becomes the prosecutor. Cases like Chicopee Lions Club from this court recognize that sometimes these functional roles do merge. And so, for example, in Chicopee Lions Club, the DA was functioning both and simultaneously as an investigator and an advocate, but the advocacy component entitled the DA to immunity. Kalina, I think, is tricky, but I also think it's inapplicable because it was clear there that the prosecutor wasn't acting as an advocate. The Supreme Court tells us that She did not have to, and she was not required to sign that affidavit in order to act as an advocate. Here, by contrast, Ms. Plouffe necessarily had to be the person who signed that affidavit. The statutory language tells us that it must be the petitioner who provides the factual allegations under oath in order to initiate the case. This court's decision in the Lillian case tells us the same thing. So in order to be an advocate, in order to serve the prosecutorial function, Ms. Plouffe had to be an affiant. And in being an affiant, she was fulfilling a necessary condition of being an advocate.
Well, this case is hardly clear, and the minority of circuits go against you. But when you initiate proceedings with the C&P, I understand that the procedure in Massachusetts requires the social worker to have an affidavit. But isn't the nature of that affidavit sort of more like an arrest warrant than it really is what you would expect to initiate proceedings? And how much are we in our determination? We're dealing with Section 1983, and the immunities issue, as I understand, is a common law issue. Well, we're dealing with a federal statute. But how much, if an arrest warrant and a C&P affidavit are really providing information that the affiant has based on his or her own personal knowledge, how much are we limited in this doctrine by the particular procedures of Massachusetts C&P? How much is that limiting our doctrine?
Well, I'll take both of those questions, Justice Lloyd, maybe starting with the second one. The issue here arises under federal law, of course, but at the same time, it can only really be decided by reference to our state law and the unique functional role that our state law assigns to our social workers. So there are cases on both sides, but I think when we take a broad view of those cases, what we see is that they are really turning in large part on the particulars of state law. Now, with respect to the warrant, the care and protection petition and affidavit is not like a warrant. The petition and affidavit are not pre-adjudicatory documents. These are documents that are actually initiating the case in the juvenile court in circumstances where Ms. Plouffe, as the petitioner, is going to be subject to an adversarial proceeding and cross-examination within 72 hours. So if we're looking for an analogy to another area of law, we think the right analogy is not to the warrant, but as the DC Circuit held in the Gray case, it's to something more like a verified complaint and a motion for temporary restraining order asking for interim relief. Now,
Can I push you on a variant of Justice George's question, which is, so before we get to this affidavit and the filing of this piece of paper, there's an investigation that goes on, and there are documents usually prepared. Those of us who've reviewed a lot of these DCF, there are huge amounts of, at least emails and paperwork going back and forth. A lot of these things involve lengthy investigations. None of that is part of the prosecution. It's sort of part of the investigation, but that's the basis for the affidavit. I'm trying to understand, we're going to provide absolute protection for the affidavit, but all the work that went into it is not going to be protected, right?
and this is this is a dividing line, I think, Justice Kafker, that's common in the prosecutorial immunity world, the classic prosecutorial immunity world too, when a prosecutor seeks an indictment or takes a case to the grand jury, that is also necessarily based on an investigative case file. And
but Kalina sort of kept a clean division by saying the prosecutor shouldn't be, because the police do the investigation, they should have, any kind of attachment should have been done by the police. It just seems like what we've got is this statute imposes this onto the process. And I just don't know if it can, as Justice Lowy was saying, sort of convert the common law privilege somewhat. It seems to shape the common law privilege the way our statute is written.
I do think it's all about the statute. That the statute requires the social worker to provide the factual allegations under oath in order to initiate the case, unlike with the prosecutor in Kalina. Another case that I think is helpful on all of these points is the Second Circuit decision in the Flagler case, which isn't a social work case, but it's one of the ordinary post-Kalina prosecutorial immunity cases. It's from New York. And what the Second Circuit says is where state law requires a prosecutor to personally sign a factual affidavit under oath in order to be a prosecutor, in order to perform the advocacy function, that is entitled to immunity. And Kalina doesn't
what's the name
require a
of that
different
case?
result.
What's
That's
the name of that?
Flagler from the Second Circuit.
Okay.
And that logic then gets picked up in some of the social work cases, like, for example, Bausch from the Sixth Circuit, which then became the binding law of the Sixth Circuit in the Brent case, which tells us that when a social worker has to file a case initiating affidavit in order to be an advocate, in order to serve the prosecutorial function and actually start the case, that is entitled to immunity, and Kalina doesn't require a different result. So I think the Superior Court's judgment here was very consistent with the letter of Kalina, but also consistent with the spirit of the Kalina case as well. Because we
So
can,
counsel, may I just ask you one thing?
of course,
So let's just say we take your view and after the fact, come to the information that the social worker lied through their teeth. And then somehow, once that information comes out, a separate civil case is filed. In your view, nothing could happen.
in our view, the collateral civil litigation would be barred by absolute immunity, which is not to say, Justice Georges, that there are no consequences. There should be consequences.
What would be the consequences?
There are several. First, all DCF social workers since, I believe, 2014 or 2015 have been licensed. The board, they are all subject to professional consequences. The Board of Registration makes both lying generally and deceit to a court cause for serious discipline. The department takes this very seriously as an employment matter. And maybe most directly and importantly of all, there is what happens in the juvenile court. There is contempt, there is perjury, and there is more informal admonishment, which I think is important when we remember that these
Okay,
are
so, but all of those consequences may be personal to the social worker, but there isn't any vindication of the family who had the child taken away, and certainly there isn't anything that's done to the trauma of the child having been taken away wrongfully.
and
Just want to be, is that your understanding that there's,
that is not our position, Justice Georges. Our position is that the avenue for that vindication is at the 72-hour hearing in the juvenile court, the very point of which is testing the social worker statements in the affidavit. And in this case, that 72-hour hearing was waived by the plaintiff.
And at that time, if your brother is right, there is an absolute immunity because again, the affidavit and the petition haven't been filed yet. We're still in the investigatory phase. So they could be sued and for what happens prior to that affidavit, can't they? I know you want us to in dicta say it goes beyond that affidavit, but I think you may be asking for something you don't want. Because at that stage, it's probably in the investigatory. Until that affidavit and petition's filed, they don't have absolute immunity. They have qualified immunity, right?
Actions that are wholly investigatory are not entitled to absolute immunity, no doubt about it. And I think you're referencing a portion of our brief on the very last page. And our point, Justice Kafka, is merely that this court's decision in Chicopee and the Supreme Court decision in Imbler merely recognized that sometimes the line between what is investigative and what is prosecutorial is hard to find. This court's decision in Chicopee recognizes that sometimes both functions are performed at the same time. I don't think, to be clear, that this is one of those cases. We do just think that speaking too broadly about that issue tends to misreflect the state of the case law, both from this court and the Supreme Court.
But just to be clear, you're saying that the family could be vindicated at the 72 hour hearing.
Absolutely, Chief Justice Bud.
And that's how you get around, I mean, that's how you justify anything that happens after that being.
As I believe both Justice Kafka and Justice Lowy pointed out earlier, the custody decision here belongs to the juvenile court. And the way to test the juvenile court's initial decision is at that 72-hour hearing. And that is the place to test the social worker's statements as well.
Thank you. Does anyone have any further questions?
No, thank you, Chief.
Thanks so
No,
much.
thanks. Thank you.